Untitled Chapter, and another in the Secretary of State for the Home Department.
Yes.
Please, Your Ladyship, my Lords, I appear for all of the appellants in this case, together with my learned friend Stuart, who you have noted appeared below in all of these appeals, and so is here today to atone for her sins. My learned friend Mr. Lewis appears for the Respondent Secretary of State in this matter.
Yes. Now, if I can tell you before we start that we've all had an opportunity of obviously reading the judgments, of reading the updated skeleton arguments, for which thank you both, as I'm sure you had to do that in rather of a hurry, so we're very much appreciative that you've managed to combine it in one document. Thank you. We've also looked carefully at the relevant statutory provisions and the codes of practice. I think we're each of the view that this, at the moment, there's a very generous time estimate, and I think that we
took the same view, I think. Yes.
I think we all anticipate we should be able to deal with the matter as fully as is necessary in the day.
Yes, well, I'm grateful for that indication. Thank you.
So, where do you want to start?
Well, lady, my opening comment is this, if I may. To a significant degree, these appeals are really about the prevention code of practice. And to
sorry, could I just interrupt you before you get into your flow? One of the things that we had wondered about is we see from the papers that a new code is going to be introduced very soon, or new statute.
Yes and no. I was going to deal with that.
Fine, take it in your own time.
Thank you very much. But yes, but to a significant degree, it's the existing prevention code that I think, by and large, we are concerned with.
Oh, we understood that. We just wondered whether or not, whilst obviously very important for these three cases, it's effectively going to be thereafter academic, anything we say.
No. Forgive me, I can put it this way. There is a bill before Parliament at the moment. I believe it's called the National Immigration and Nationality Act, a bill of 2021/2022. It is at early committee stage at the moment.
Yes.
Schedule 4 of the bill, in effect, repeals the need for a prevention code at all, but leaves in place the level of penalty code, but I suspect it will be amended somewhat. But perhaps more importantly for our purposes, what it also does is it gives the Secretary of State the power to set out in secondary legislation by statutory instrument a list of, if you like, rules by which the responsible persons must comply in order to avoid the imposition of a civil penalty. I anticipate that the Secretary of State will, in terms, reenact an improved code of practice in statutory form, and that, one suspects, will deal with the sorts of complaint that we bring before you today. But it will take a statutory form.
Yes.
Whether or not that's for better or worse is not for us to consider. And given that the statute, the bill is at a fairly early committee stage, for my own part, I wouldn't expect to see it enacted into legislation late next year, perhaps even the year after, depending on what the parliamentary timetable permits. The reason I put it that way is because whilst the prevention code's life estimate is fairly short, it looks backwards to the large number of cases that are in the pipeline before the lower appeal court, the county courts, and because penalties are being imposed, I won't go so far as to say on a daily basis, but certainly on a weekly basis, it looks forward to the point to which the new legislation is enacted, and so is very much alive and kicking for our purposes. I hope that puts it...
No, that's extremely helpful. I think we were all anxious to feel the context of that.
Yes, thank you. Well, I'm grateful for that.
While we're preventing you from starting, can I raise two questions which I'm sure you will have in mind, but would certainly help me. First question, where is monitoring in the Prevention Code of Practice?
It is not.
I think the answer is it's not.
It's not. And this you will have seen is one of our complaints. It appears in the level of penalty code, and one of our complaints you will be alive to is that county court judges and the Secretary of State have used monitoring, or the absence thereof, as a way of, if you like, negating the presence of an effective system of prevention, and we say they are wrong to do that.
So question 2, Annex 1 to a determination letter
Yes,
refers to 5 obligations,
it is wrong.
in the sense that where it refers to monitoring, there is no basis in the Prevention Code of Practice.
Just so. That's
your position.
That is why, my lord, I interrupt you to say boldly it is wrong. It is a point that we have been concerned with some time in the lower courts, because in effect, and I don't mean this in the pejorative sense that it sounds, but when Border Force send out Annex 1, they are misleading those to whom they are sending it as to the requirements that they must meet.
Well, we'll hear in due course from the Secretary of State whether they accept that that's wrong.
Yes.
Thank you very much.
Malay.
Do begin.
Thank you. Put it written down so I'll get back to what I said here.
I'm so sorry, but it's been most helpful.
I'm a thick skin and an old hack. To a significant degree, these appeals, as I think we've already identified, turn on the Prevention Code of Practice and the way in which it is interpreted, and I would go so far as to say imposed, by the officers of the Border Force on behalf of the Secretary of State. And I say that for this reason. For if we didn't have the code, or were it to be more tightly drawn, as I think we've now seen it is to be, or if it was construed in perhaps more generous terms as suggested by this court in the International Transport Rough and Bolly transport cases, then I rather suspect we probably wouldn't be here today. And it's interesting to note on that point, and you've already foreshadowed it, that there isn't much life left in the code anyway, and one can speculate that one of the reasons for that might be because the code as it stands at the moment is not the clearest of documents, and if you are a haulier from overseas with some or no English, having to read that to understand what your duties are, and I know it's published in other languages as well, but it's equally inconsistent in those other languages, and those other languages can't take account of the context in which it's written in English. Parliament is, I would say, considering, is going to recast the thing and replace it, which I suppose would take away a lot of the ambiguities and inconsistencies that my Lord has highlighted but too recently.
I'm sure you'll find others.
I'm sure I will. I have to confess, my own friend makes the point in his skeleton argument at one stage that goes, this is a harsh system and necessarily so. I disagree with that for reasons which we'll come to. But it is interesting to note that when the new legislation is enacted, the system will be the much harsher, because, and this is quite an interesting point for another day, but in short, the system allows the Secretary of State to impose penalties on those who have not carried clandestine entrants, but who simply do not have what what is required, an effective system of prevention. So whether or not clandestine entrants have got into your vehicle, if a Border Force officer asks you for your system and says you haven't got one, that is a penalty regardless. But that, as I say, is a debate for another day. Can I headline my submissions in this one? I propose first with dealing with all of the appeals in terms of the statutory scheme together to establish the basic principles, if I might, or the first principles, and then go on to deal very briefly with each individual appeal, hoping to relate the elements of those appeals to the statutory scheme as I suggest it ought to be interpreted. The scheme was established, as you know, in 1999. A quick, very quick trot through the process because you are all very familiar with it by now. And effectively, it gives the Secretary of State a discretion as to whether or not to impose a civil penalty on any responsible person, i.e. being the driver of a vehicle, the hirer of a vehicle, the owner of a vehicle, or the employer of the driver, in the event that clandestine entrants are discovered inside the vehicle and it can be shown that they do not have an effective system of prevention for those clandestine entrants in place, in operation on the day in question.
That's not right.
Forgive me.
The liability arises, but there is a defence if the haulier demonstrates that they have an effective system.
Forgive me, my lord. At face value, yes, and it may be because I'm confusing the way the system ought to work with the way it is interpreted. Because the statutory defence, putting aside duress, which is not relevant in almost every case, the statutory defence works in two ways. At first, it is for the carrier, we'll use the carrier as the shorthand, to demonstrate that they had in place an effective system of prevention. And secondly, it is for the carrier again to demonstrate that on the day in question, the effective system was being operated properly by the driver. And one of the arguments I intend to raise is that quite often, and as you will see in these cases, what happens is that the Secretary of State will say, you've got a pretty good system in place, but it's been let down because your driver on the day didn't operate it properly. And the phrase, I think, His Honour Judge Coe, or Her Honour Judge Coe said, I can't remember which one, refers to the proposition that a driver on a frolic of his own, a driver who, as I say in my argument later on, had not done that which he had been properly trained to do, invokes a penalty imposed by the Secretary of State because that limb of the defence in operation, properly operated on the day, was not in place. In due course, I will argue that that's an unfair process, but that's for later on. But in terms, my Lord, yes, that is the statutory system that's imposed. It came before this court in the now much quoted case of International Roth GmbH and others, and the Secretary of State for the Home Department cited 3 weekly law reports, page 344, the 2002 volume. Ostensibly, the reason it came before, I'm not going to take my Lord Lady to it at the moment. I've got the extracts that I rely on in all of the authorities I've reproduced in my skeleton argument to save whizzing through the pages, but there. It came before this court in that context because it was said by those acting for international transport Roth that effectively what had been imposed was a penal system in contravention of the European Convention. And as a result of the decision of this court in that, which found in favour of Roth, the Act was amended to add section 35A, which is the defence, forgive me, the right of appeal against the imposition of the penalties to a court, in this county. I'm not so concerned, forgive me, with whether or not the scheme itself is a penal scheme or a penalty scheme, because that's long since been decided, and it's where we are. I am, however, concerned at what both Lord Justice Simon Brown and Lord Justice Laws said when writing their opinions as to the outcome of the case in international transport Roth. And I've reproduced 2 extracts of page 4 of my skeleton argument, paragraph 8.2. Because this is, if you'll forgive me, my answer to my learned friend's point that appears later on in his skeleton argument, which goes, this is a harsh scheme, and intentionally so because of the societal damage caused by, I put it kindly, unregulated immigration. But that was not the view that was taken by this court in 2002. Simon Brown, his paragraph 25, says this. Other important and clearly countervailing feature of the scheme seemed to me to be, first, the obvious obvious need for firm action of some kind to combat the acute problem of illegal immigration, which hereafter I shall call the social goal. Second, the scheme lacks any criminal sanction, and I emphasise this point, and is clearly designed rather to encourage vigilance than to punish the dishonest. Insofar as it achieves the latter, it does so lightly and to avoid the Gilbertian situation of penalising the careless and allowing the dishonest to escape scot-free. I say that's important because it rather sets the tone for the way I submit in which this scheme ought to be interpreted and applied by both the Secretary of State and below her the border force officers who are working at the coalface, if you like, in dealing with these penalties. Later.
No, I'm
Oh, sorry.
No.
I also rely on a passage set out at paragraph 108 by Lord Justice Laws, sadly no longer with us. And he was a dissenting voice in the constitution of the court in Roth, but dissenting not on this principle, only dissenting on the main issue before the court as to whether or not the statutory scheme then was non-compliant with the ECHR. But at page 108, His Lordship says this: as regards the defences themselves arising under section 34, I have two things to say. First, I think they represent an acknowledgement by the legislature that in a situation where it is agreed on all hands that the absolute prevention of the cross-channel trafficking clandestines is impossible, a balance ought to be struck in the legislation so that a responsible person who can show he's complied with the code and in effect done his best to avoid the carriage of illegal entrants in his vehicle should be excused a penalty. Secondly, and this is in a sense a function of the first point, if the case were that this traffic could be prevented altogether, if hauliers and others took sufficient care, there might well be a case for allowing no exceptions by way of defence, since then every instance of an immigrant's successful arrival here would also be an instance of want of care by the haulier. Thus again, His Lordship says, the section 34 defences acknowledge the impossibility of absolute prevention. Again, in my submission, that sets the tone for the way in which these provisions in the statutory scheme ought to be applied. And I note that it might be said that Lord Justice Laws refers to a responsible person who can show that he has complied with the code, and I would take issue with him very respectfully only on that point, because of course the code is not prescriptive in the sense that there is a requirement that it ought to be published in the statute, and there is a requirement that those who are operating vehicles into the United Kingdom must make use of the code, but when determining whether or not civil penalties ought to be imposed, the Secretary of State is required to have regard to. And have regard to, in my respectful submission, imports a lack of prescription.
But I'm not sure you're disagreeing with Lord Justice Laws. No. He's saying that if you do comply with the code, then you should be excused. He's not saying that if you don't, you inevitably have to pay a penalty.
My Lord, it's an interpretation I thought about, and then perhaps took the less positive view of it on the basis that I wondered if your Lordships and Ladyship might look the other way and suggest the opposite. But of course, I have to respectfully concur with what you say. That is the better way of looking at it. And it brings us back to the proposition: is the code prescriptive or not?
But if you read the statute and the code together, as you say, you use the phrase, it's not prescriptive in the sense that the statute, neither the statute nor the code says if you comply, you're deemed to be effective. If you don't comply, you're deemed not to be effective. But the thing about having regard surely means that if you can show that you've complied with the code, that would be strong evidence, or that would be evidence in support of a submission that your system was effective.
Again, I can't disagree with that. Your Lordship corrected himself from strong evidence to evidence of. I simply recall slightly from the proposition that it's strong evidence because, to be frank, what is required is an effective system of control. And if I were to be really bold, I would say if I put two big strapping men in the back of my truck with big sticks, I have an effective system of prevention. And the Secretary of State, apart from moral complaints, could not suggest I did not have an effective system, but it had nothing to do with a code of practice to which she must have regard to. Now, that's not a particularly elegant way of putting it, but I submit it makes my point and concurs with the point your Lordship makes, which is look at the code, identify which elements of the code, if any, the carrier in question has sought to apply, and determine on the basis of that and such other evidence as is available whether or not an effective system was in place. And my overall submission here is that that is not, at the moment, what the Secretary of State or the courts are doing, the lower courts. What they are doing, in my submission, and we can see it in these appeals, is they are using the prevention code as a template, if you like, saying, if you don't have this aspect of the code in place, then you do not have an effective system. And I know I'm moving ahead from what I've said in my skeleton argument in that respect, and I rely on everything I say in my skeleton argument. But given that, as you've already said, you are all fully seized of all of the detail of the appeal, I can put it this way. If a carrier has all of the elements of the code but one, i.e. a driver has failed to produce a set of written instructions upon demand, query, does the failure to provide that set of restrictions on demand make the system of prevention that the operator has put in place, the carrier, any the less effective?
But the example you just gave, and that's one of the things that I need help with, is where the dividing line is between B and C. Because if you've got your perfectly effective, and I use the word cautiously, system in place in compliance with the code, but your driver simply fails to comply, momentary lapse of attention or idleness, it doesn't really matter what, but there's an error in that respect, surely that then means you've failed to establish your defence on C, not on D.
Yes, I accept that on a strict black letter law reading of the statute, but I advance two arguments against the proposition, if I may. The first is, if one likes a rhetorical question, did Parliament really intend to set up what in a loose form might be described as a vicarious liability system, where the failure of the driver to do that which he has been trained to do, to use the equipment that he has plainly been provided with, and to conduct all of the checks that with training and education and documentation that is expected of him, is it right that the haulier, the carrier, when the driver, having had all of that, fails to implement but one aspect of the system,
No, but it's not vicarious liability, is it? The defence has the three elements, right?
Yes.
And if you show your effective system, but due to driver error, you actually don't get home completely on the totality of the defence because the operative system's gone wrong.
Yes.
Then that moves on to the next stage, and there's then the discretion as to whether to have a penalty, and so the person imposing the penalty could easily say there was an effective system. This is driver error. They'll then look, well, if there was inadequate training, they could say you've still got to pay a big penalty, or they could say actually it's a minimal penalty because this was the driver's fault. I don't see why you're saying that's vicarious liability.
I meant it in the very loosest sense. What I really meant was, is it right to lay at the shoes of, at the feet of the careful carrier, the errors of his driver?
We can't go round. We can't undermine this the statute's actually is absolutely clear. You've got to establish all three elements in order to affect. And you're saying that's not fair. That's not right, and we can't do anything about that.
If I may, that's the biggest difficulty with my first argument, and I acknowledge and recognise that. But the reason I mention it is because it takes me on to my second argument, which
before you get there, sorry to interrupt you, but before you get there, it's not just the terms of 34C. The whole way through the statute, it's if I can put it this way, endemic that the hirer, the owner, are treated as being responsible people.
Yes.
And to my way of thinking at the moment, and you may wish to shift me from this, it is clear that the system that has been put in place both by statute and under the Prevention Code is intended to place responsibility on the owner, the hirer, the employer.
It is. I don't disagree with that. I can't disagree with that. What I say about that is this. My first argument, I accept, is bound to fail. But I advance it anyway on the basis that it leads me on to my second argument.
Right.
And this is because of the prescriptive nature, which appears to be a prescriptive view of the Code of Practice, which appears on the face of things to be taken by the Secretary of State to the Prevention Code. If we take the situation where the carrier has done everything that he ought to do, but he has been let down by his driver, for instance, by a failure to produce written instructions, but the instructions were provided by the carrier, then surely that must be precisely where the exercise of discretion ought to fall, and not the exercise of discretion as to whether or what the level of penalty ought to be, because there is nothing in the legislation that says there is a specific discretion related to the level of penalty. That's dealt with by the Code of Practice. The discretion lies entirely within the ambit of whether or not to impose a penalty in the first place. And so if you have a carrier, a responsible person, employer, who has that ideal system in place but is let down by their driver in perhaps a less serious way, surely that is the situation in which the Secretary of State ought to say, this operator, this carrier has done everything we could expect of him. And yes, look, he's also complied with as many elements of the Code of Practice as he has, and he's been let down by his driver, then he ought not to, of himself, be penalised for his efforts, for two reasons. The first reason is because, regardless of his position, the penalty imposed on his driver is going to fall back to the carrier anyway because of the joint and several liability aspect of the legislation. And secondly, because when one looks at what the overall cast of the scheme as suggested by Lord Justice Laws and Lord Justice Simon Brown and Lady Justice Gloucester in the later Bolly case, the bit that goes, this is about encouraging operators to do what they ought to do rather than penalising them for, in this argument, the failures of their drivers when they have done everything they ought to. And I would emphasise on that point that we must not lose sight, as I'm afraid the lower courts do from time to time, as is manifest in these cases, we must not lose sight of where that discretion lies. And it lies in respect of the decision whether or not to impose a penalty. It does not lie in the decision as to the determination of the level of penalty to be imposed.
Because it's a two-stage decision-making process, isn't it? One, should the discretion... Well, three. One, do they get home on one of the defence?
Yes.
No. Move on to two. Should the Secretary of State, in the exercise of his or her discretion, impose any penalty? Three, if the answer to number two is yes, then what level of penalty is appropriate?
Your ladyship took 10 seconds to say what I took 5 minutes to say. That is precisely the position I advance it to be.
Do you accept that training of drivers is part of an effective system.
Absolutely, it has to be.
So the difficulty with that is that even if you have a system which is in all other respects effective, if you have a driver who fails to comply with the system, that at least raises questions about the effectiveness of training, which probably can never be answered.
Oh, forgive me, it can. Can I? If I give offence, I don't intend to. I put it that way. The fundamental system works like this. When a driver is, and I'm loath to give evidence, but I know my learned friend has conducted these cases below and would agree with me, I hope. The position is this: when a vehicle is stopped at one of the control zones or at Dover, the driver is asked for his documentation and his vehicle is checked, and in the event that clandestine entrants are discovered, they issue him with a letter called an IS-11D letter. It's a questionnaire, which he takes away with him and fills in and completes and returns within 14 days. On the same day, the same document is also sent to the carrier, the owner of the vehicle hire, and they too are required to respond to that document and send it in within 14 days. And one of the questions, my lord, that is asked in that is, what training do you provide? And they are encouraged to provide written evidence of the training that is provided. But the state, it then goes further, because you'll be familiar with the notices of objection. Those are often dealt with by lawyers both overseas and in the United Kingdom, who have regard to what is required. And one of the stages in dealing with a notice of objection is to provide the evidence that your lordship would wish to see in relation to the various aspects of the effective system, including training. And again, when one gets to the county court appeal process, one takes witness statements and produces evidence. And again, the evidence that one seeks to produce is not always there, as the lordship points out, is evidence of an effective and comprehensive training system. And so at every stage of the process, there is an opportunity for the employer to provide the evidence of a comprehensive training system, of the documentation he gives his drivers, of any retraining that he does, of the security equipment that he gives his drivers, and the instruction as to what he must do on the day. And my lord respectfully is right to say, if that evidence is not there, then there's no effective system, because that has to be the starting point of any effective system. But if the evidence is there, and it is there in comprehensive form, and I've seen evidence where employers have provided training packs with signatures and dates of drivers to acknowledge they've had the training. If it's to that extent, then I would suggest my lord's question is answered.
The puzzle about your analysis seems to me to be this. If the responsible haulier who has a perfectly effective system, excellent training and all the rest of it, is nonetheless to be fined or exposed to a penalty because his driver doesn't operate the system responsibly, how can it be that the right answer to the exercise of the discretion is to exercise it in the haulier's favour on those facts? Because otherwise the form of the statutory defence would be different. It would stop at B, wouldn't it, for the haulier? Rather pointless to go through all of that and then say, well, you don't get a penalty because you've complied with B.
The Lord has highlighted the conundrum I had when I sought to advance the first argument, which was bound to fail, which was the statute is very clear. In order to meet the statutory defence, you have to meet the provisions of B and C. And if you don't, then you fail. And it's a point the lady took me to. But if you fail on the statutory defence in whole, which is my lord's point, where do we go from there? Well, that, I say, is where the exercise of a discretion comes in, because there's no point having a discretion if, upon the failure to meet the statutory defence for some reason or other, a penalty is going to be imposed.
But equally, my point is the opposite.
Yes.
There's no point in having a discretion if it's always going to be exercised in favour of the haulier.
Well, this is well, I don't suggest, forgive me, I don't suggest it's always going to be exercised in favour of the haulier. What I suggest is that where a haulier has done everything that we ought to expect him to do, and put in place what at face value it looks like an effective system if it had been implemented on the day, and that he has failed but for the acts or omissions of his driver, then the driver will be penalised, and the exercise of discretion ought to take effect in favour of the operator. Because otherwise, as Malone points out, what is the point of having the statutory discretion?
But surely that's all there. That could happen. And
does.
surely it's, well, we can only deal with the 3 cases that we've got before us, and which you're submitting. The exercise of discretion was used, I presume, improperly. I mean, we can't just...
Forgive me, I don't suggest improper, I suggest that...
wrongly then, sorry.
Well, just not exercised in one case.
The other problem is that from our much more limited experience of these cases than you obviously have, if you take the 2 link cases, the features relied upon by the Secretary of State include, for example, previous breaches. So you might have a case where on paper you've got an absolutely marvellous system, but unfortunately your lorries are being stopped once a week, and despite this marvellous system, they're fined repeatedly with multiple clandestines on them.
Yes.
So that you couldn't. All I think I'm really reaching towards is it is seldom going to be a case where the only feature that the Secretary of State has to have in mind is that this is purely a driver error.
There are, again, I'm full of true answers. There are 2 answers I would, or responses I would make to that. The first is this, and forgive me for putting it this way, by the time it gets to the county court with which we are concerned with, it is a rehearing of everything, and accordingly what the Secretary of State did or did not find is irrelevant or immaterial to what the court finds. Of course, the Secretary of State will want to advance submissions that we thought this and this was good, but we were concerned about this and this, and no complaint can be made about that. But what we're concerned with here today, if I may say, is regardless of what the Secretary of State found at the early stage, what we're concerned with was what the judge's findings were on the appeal to the county court. That's my first response, if I may. My second is this. If I run 5 vehicles and one of my vehicles gets stopped with clandestine entrants, then I have a 20% failure rate. If I run 1,000 vehicles and one of my vehicles gets stopped, I have a 0.1% failure rate. And that's a problem with the approach that goes, well, you've been subject to previous penalties. Because an operator running 1,000 vehicles, and there are operators that run 8,000, 10,000 vehicles a year into the United Kingdom, an operator running 1,000 vehicles is inevitably going to have a higher strike rate, if you like, than is the smaller operator. So the tool that goes, well, you've had previous penalties, is a very, very clumsy tool with which to strike at the harm that's done.
It may be a factor. That's all I'm saying.
I accept.
And so you're suggesting as almost as a principle that if it is purely driver error on this occasion, then there should be no separate penalty.
Yes, I think I am.
I think you are.
Yeah.
And all the pushback on that is that certainly on the cases that we've seen, that is not the only consideration that has come into play.
In that, I would go back to my first submission. Respectfully, what we're concerned with here today is not what the Secretary of State did or didn't find, because we are a rehearing.
I'm not sure I accept that, because although in the County Court it's a rehearing, the question for the County Court is whether the Secretary of State's wrong.
No, forgive me, it's not. I do apologise, but it's not. That's the whole point. It is not a public law review of the Secretary of State's decision.
You want us to lay down criteria which will then become of general application.
Yes.
Primarily in the County Court, but we have to have in mind that anything we say might have some influence on the Secretary of State as well.
I accept that, but with respect, that's a different proposition
Right.
to the one I'm arguing, which goes, this court is bound by the findings of the court below,
Yep.
and is not to go behind them. And the findings on the court below do not deal with aspects or considerations such as this is the first occasion, etc. Because it is not a public law review of the Secretary of State's decision. And I fear that His Honour Judge Gosmar, Queen's Counsel, may have, certainly in one of his decisions, where he talks about, I must consider whether or not the Secretary of State it was right to exercise her discretion, etc. And forgive me, that's not the position. And it's relatively easy to elide the role of the Secretary of State with what she has in fact done in a particular case.
But I'm sorry, I'm not quite following that, because in these three cases, largely there's agreed facts.
Yes.
So the Secretary of State made her decision on the basis of those facts.
To a degree, yes.
It comes in front of the county court, and I completely accept your analysis of a rehearing, for a rehearing, and the starting point of the county court judge will be to find facts, because only if you've found facts can you then move on to consider all the other aspects, including the exercise of discretion. But it's the same facts as the Secretary of State was concerned with. So I'm just not quite clear what you're asking us to do when you're saying scrub what the Secretary of State's found.
Because if the judge has found the same facts as the Secretary of State, then it's the judge's findings that we're concerned with. But it goes in my submission.
Well, I don't think that anyone's saying otherwise, are they?
Well, the reason I mention it is because we talk a lot about, and indeed I do, about the Secretary of State's decision-making process. In fact, what I should be talking about is the learned judge's decision-making.
Well, if you do, and just to take a specific example, what the Secretary of State calls the Fine appeal, which is one of the link cases, as you know. Paragraph 24, what we then have to deal with is turning to the level of penalty. The maximum level of penalty is 2,000 per clandestine entrance. This is not the most serious of breaches on the part of the first appellant, and a penalty of £1,200 takes this into account. The penalty is aggravated by the fact that the first appellant has previous penalties. The penalty of £1,200 is appropriate in the light of the fact that whilst this is not the most serious of breaches, the record of the first appellant, blah, blah, blah. Aggravating feature. Well, we can't interfere with that, can we?
Can I just ask your Lordship for the particular transcript?
Page 71.
It's 71. Thank you.
Now, there may be other bits of the judgment that you're going to criticise in due course.
Yes.
But we're not operating on a blank canvas here.
I don't disagree that previous penalties, the exposure to previous penalties ought not to be taken into account. But the argument I advance is that has to come into the level of penalty argument, not the argument that goes whether or not there was an effective system in place in the first instance.
Well, because that was exactly what you were arguing. I thought you were arguing that where it's driver operator error, the starting point should be consideration whether it's a nil penalty.
No, forgive me. No,
in that case, I've misunderstood you.
Well, it's my fault entirely. That's not the position. The position is not that there should be a nil penalty, because when you start talking about a nil penalty, you are getting into level of penalty territory.
So who states they should exercise their discretion to impose no penalty?
It just so.
Not nil being regarded as the bottom end of quantum.
Exactly so, because it's a separate stage. Yeah. That's the argument there. And so,
but what my lordship is saying, as I understand it, correct me if I'm wrong, is that at the stage 2, should the Secretary of State exercise her discretion,
Yes.
what I think my Lordship's saying is that in determining whether or not to exercise discretion at all, at that stage, the Secretary of State may appropriately consider whether there are other aggravating features that may make it appropriate to impose a penalty, notwithstanding that driver error was what caused the actual.
I know I'm going to be unpopular, but I would respectfully disagree.
No, well, you're not unpopular at all. We're just trying to tease out precisely how you put your case.
If you go back to the statutory provision which sets up the defence, as has been pointed out, either you make the defence or you don't. And taking into account whether or not there have been previous instances of clandestine entrance discovery in your vehicle does not answer the question in my submission, is there an effective system here?
No, I'm sorry, but I'm confusing you now. I get that completely.
Thank you.
So we've decided, as I understand it, on your submissions, we've decided that there was an effective system, B, tick, but the driver error means that you failed to establish your defence because you've tripped up over C.
Yes.
All right, so you then move on to, on your analysis, should the Secretary of State thereafter, the defence having not been made out, exercise the discretion to impose a penalty. I think what you said to my lord is that, as a matter of principle, if the failure has only been on C, not B, the carrier should not be subjected to any penalty. In other words, that's the way the Secretary of State must exercise her discretion. What I think we're testing you about is whether, in fact, that is not the end of the matter. There are other elements on the factual basis and background of the case that may properly lead the Secretary of State to exercise her discretion to impose a penalty before you get to quantum, notwithstanding that there was an effective system.
I see the point.
And one such feature could, I think my lord is suggesting, might be the knowledge that there's been a number of previous penalties.
A consideration to be taken into account
in deciding whether to exercise it at
discretion.
all. Yeah.
My argument would be that if we are going to stick to the black letter law of the statute as we must, then the decision as to whether or not there is a penalty ends if there is to be penalty by failure for, if you like, 2 and 3. And then when you get to the exercise of discretion, you exercise the discretion in relation to the facts that are in front of the judge on the day. Mm-hmm. And if one of the facts in front of the judge on the day is whether or not there has been a previous history, then that, I would argue, is a legitimate factor to be taken into consideration.
So you would accept that at stage 2, that those other extraneous features of which previous penalties...
I think, forgive me, my lady, I think we're agreeing. It took me time to get there, but I think we're agreeing that stage 1 is, ought there to be a penalty at all? And if the answer to that is yes, but for discretion, then we go on to consider discretion. Previous instances don't come into the calculation as to whether there ought to be a penalty at all, but it does come into the calculation as to whether or not.
To my mind, that's completely unreal.
No.
Completely unreal, because it is bound to be a feature that is going to be taken into account whether deciding whether to impose a penalty at all. That, for example, you've got previous breaches.
The difficulty, my lord, with that approach is that if we take cases on a case-by-case basis, what we don't know from previous penalties is the basis upon which those penalties were imposed, and we don't know whether or not a system has been improved since then.
No, but my point is much simpler. If, as is set out in the penalty code, the hirer's record of liability to penalties is a relevant consideration as to quantum, it must also be a relevant consideration as to whether or not to impose a penalty at all.
I respectfully disagree with the Lord.
I don't understand.
And I'm afraid I must, and your Lordship knows I must if that's my position. And I can see, if you like, the way the wind is blowing on that point, but I would continue to argue that the issue as to whether or not a penalty must be imposed, if you like, is solely determined by whether or not B and C are met on the day. And previous conduct can't answer that question.
So does it work both ways? Do you say then if there was a defect in the system, but the driver did everything he possibly could, he or she had done absolutely everything he possibly could and complied with the training, and albeit the training was defective, that then the Secretary of State must exercise her discretion not to impose a penalty on the driver?
That's precisely what His Honour Judge Godsmark did, and which is why Mr. Oakarts is not part of these appeals, because His Honour Judge Godsmark said whether or not there was an effective system fails because of a failure of the company to impose an internal check of the vehicle at every stop. But beyond that, driver Oakarts did everything that was required of him, and in those circumstances, I paraphrase, I can exercise my discretion not to impose a penalty, and I do so. And frankly, if the learned judge can do that, then well, that's my argument in reverse as to the operator's position when the driver lets him down.
The problem with your argument is not that you're not just saying that that can be done by the Secretary of State and the court, but that it must be done.
Oh, forgive me.
And that's not consistent with the statutory scheme, which clearly envisages the imposition of a penalty on a haulier who has a perfect system, but whose driver has let them down. And my Lord's proposition answers that problem for you, but you won't accept it.
Well, going through my mind at the time I was saying it was I was using the word must instead of may, because the statute says may. And I appeared in the body appeal and made that very argument in that appeal. No, I accept what my Lord says. The Secretary of State, the word must has no role in the exercise of a discretion. What I argue is that when considering whether or not she ought to exercise her discretion in favour of the carrier, if the carrier has an ideal system in place but it's let down by the operator, I say one would expect the Secretary of State in those circumstances to do as His Honour Judge Godsmark did in reverse and say, this operator has done everything he ought to have done, he's been let down by his driver, in accordance with the principles set out in International Transport Roth and the Bolly Appeal. These are encouragement provisions, not penal or prescriptive provisions in that sense. I can exercise my discretion in favour of that compliant operator. That's what I say.
But then, if that's the position, then effectively all you're saying is that, for example, in the HHJ Fine case, the insecure tilt cord, that the basis of your appeal is not that you need guidelines or bolstering up or changing of emphasis so far as the code is concerned, but simply that HHJ Fine wrongly exercised her discretion.
That's part of the appeal, but the reason I look for guidance from this court is because until I'd seen my own friend's skeleton argument quite recently, the position that we were advancing was that the Secretary of State was applying and the courts were applying the Code of Practice, Prevention Code of Practice, as if it were a prescriptive code of practice set in statute. And the complaint was that what the courts were doing, and in these cases the courts were doing, was that they were looking at the Code of Practice and saying, well, the Code of Practice says this, and you haven't done that, therefore you fail. And a good example is the failure to provide written instructions on demand by the Border Force officer. And if you take that view of the Code of Practice, then you leave no flexibility for the operator to impose his own systems rather than what the Border Force may take the view is their ideal system. And you lose that element of discretion, which goes, well, there is an effective system here, it's just not the system that they want. And that was the original starting point. When I received my learned friend's skeleton argument, I note that he headlines from a group of paragraphs that in fact he accepts the argument that goes, this is not a prescriptive code, it is indicative, and indeed it's strongly indicative for judges and Secretary of State to identify elements which may go towards an effective system, but is not the be-all and end-all. And so, although we were not in agreement until I saw his skeleton argument, on that point at least we are now in agreement, which is why it was advanced that way in my skeleton argument.
Thank you.
So
Yes, keep going.
thank you. We've covered, I have to confess, quite a lot of the points that are, so if I can take a moment and skip through.
No, do, please.
Thank you. I ought to, for the sake of completeness, cite what Lady Justice Gloucester said in the Bolly case. It appears at paragraph 8.3, and it's Body Transport BV in the Secretary of State Loan Department, 2016 EWCA 783. At paragraph 48, the scheme was introduced to meet the increasing scale of illegal entry into the United Kingdom. As Mr. Justice Sells said in Bogdanovich in SSHD 2014 EWHC 2872, the scheme of the 1999 Act is to place the burden of combating clandestine entrance on the haulage industry, and I've highlighted, to encourage carriers, such as lorry drivers, not to transport clandestine entrants into the United Kingdom, and to exercise care to ensure there are no stowaways hidden in their vehicles when they come into the United Kingdom from the future.
Forgive me, which paragraph of Bolly is this?
This is paragraph 48, but it's reproduced in my skeleton argument.
Well, I know, but it is paragraph 48 on page 201. I just think you might mean paragraph 46.
You may well be right.
I mean, I had this difficulty yesterday, but when looking at the papers, but I think the passage you just read comes at 46.
If I've misquoted the paragraph number, then I'm in error.
If you look at the top of the page.
Yes, as Mr. Riley-Smith submitted, yes.
That's what you wanted, wasn't it?
Correct, yes.
Because although I read it a couple of times, I wasn't entirely sure that paragraph 48 really took matters much further.
It doesn't. Thank you. It's 46. Thank you. But I only cite that paragraph to reinforce my earlier submission as to the nature of the scheme and the way it ought to be implemented.
Well, I'm very glad you quoted it, because I see I've
agree?
seen it. I have absolutely no recollection of the case.
That you were.
It is a long time ago.
Yes. At paragraph 8.6, I set out the view of Lady Justice Gloucester as to how the scheme ought to be implemented in terms of the approach that the lady we've discussed, effectively the three-stage approach, and so I shan't revisit that. Then I deal with the agreement with the other side. And then I suppose I go to paragraph 13 of my skeleton argument.
Sorry, 13.
Yes.
Thank
It's
you.
on page 7.
An effective system.
Yes.
Yeah.
I'm going to apologise because I have no plastic container and I need a drink. Would you forgive me?
Of course.
Unless
Have
there
you got any plastic glasses? Just drink from your bottle if we've nothing else.
I think there's
Yeah.
a policy of not having them.
Oh, no, don't worry. I can see one over there.
If you're happy to, I think my lady said drink from the bottle.
You do feel free to drink from the bottle.
It's
I've no idea
It
what.
would have been a capital offence before COVID.
No, that's why I hesitate. Thank you.
Yes.
Paragraph 13 of my skeleton argument. Code of practice. I'm afraid I complain bitterly about the code of practice in my skeleton argument, and I maintain those complaints. But it has to be said that one of the reasons I complain so bitterly about it is because I did not realise at the time I read this that we are in agreement
Yes, you were worried that it was prescriptive rather than...
Yes.
Yeah.
But I'm also concerned, as I think I set out, that there are, it's not entirely clear as to what is expected. And in part, and I'm going to skip forward because I know you have some of the points, but in part, it seems to me with respect that the issue that His Honour Judge Godsmark was so unhappy about is the proposition that drivers are required, every time they make a stop, to check their vehicles for clandestine entrants, to check the padlocks, the seals, etc., that they go inside the load area and check inside the load area. And the reason that exercises me is because the Code of Practice doesn't say they ought to do that. And as a practical proposition, it's, I'm afraid, simply just doesn't make sense. And so the question is, if regard is to be had to the Code of Practice by those who have to implement it, that is the carriers, then surely they ought to know what is expected of them, so that when they come to the county court to complain about the penalties imposed, one of the complaints is not about not understanding that which they ought to or ought not to have done, and what is expected of them in a clear manner. And if one goes to the Code of Practice, and I set out the relevant provisions at my paragraph 24.4, page 10. And if I may, I'll trot through them because they're relevant.
Okay, could you just help me? Because I think you're going to go through section 1.2, measures to...
In due course, yes.
Right. Just so that I can picture this. It is immediately or before arrival at UK immigration control at Coquelle, which is somewhere I've been, so I can visualise it. Is the suggestion that within sight of the border control, so as you come to the first barrier, a lorry driver is meant to, at that stage, to get out and do these checks, or what?
Yes. Interestingly, I know my ladyship doesn't recall the case of Bolly, but immediately before Bolly, the same constitution sat on a case called ICS Car.
Oh, did I?
Where that, where I wasn't involved, but was observing because mine was and it was that very point that was litigated in that case. I'm not sure whether it's cited or not, but certainly the argument was advanced by the Secretary of State in that case, and I don't see it being argued here, is that that was precisely the position, that the vehicle ought to be checked, that final check ought to take place.
As you come down the ramp?
As you come down the ramp, which frankly, I'm afraid is a ludicrous proposition.
Well, it certainly doesn't happen.
Of course it doesn't happen. And forgive me, and it doesn't happen because if one only has to look around, A, at them, to observe the number of vehicles heading into Coquelle to get the train, number of trucks, and B, to look over the ramp and observe the number of persons who would wish to enter the United Kingdom, awaiting their opportunity to climb into the backs of lorries where drivers have just removed the seals and thrown open the doors in order to check that none of their comrades are inside the vehicle. And we've all seen television scenes of threats and all this sort of, and that's all by the by. But the proposition that a truck stops in the place my Lord has suggested it ought to stop is not one that can stand reality.
I must say I find 1.2.5 rather difficult. You're going to tell me that I've dealt with it twice before, probably, but but I do think it is a rather difficult clause.
And so you begin to see why I complain so bitterly about the code generally. But yes, but what's perhaps equally, and I use the word interesting advisedly because it interests me, but I know it doesn't interest a lot of other people, is the code in other respects requires, it picks out Coquelle specifically, and it is 1.2. Measures to be taken immediately prior to the vehicle boarding the ship, aircraft or train to the United Kingdom, comma, or before arrival at the UK Immigration Control at Coquelle. So we're split. If you're going via the train, you go to Coquelle and you pull up in the position the law suggests and you throw open your doors and do your checks. But if you're going to Calais or Dunkirk or any of the other Channel ports, you don't pull up.
But that's, forgive me, but isn't that simply because that's where the effective border is? And that's, the idea would be, it's your final opportunity before you are irrevocably committed to having brought them in. So at Coquelle, once you go through border control, you know there's no border control the other side. And
well,
am I being unrealistic?
No. As far as Coquelle is concerned, no. And that's clearly the intent behind that particular provision. The problem arises with Calais and Dunkirk and Zeebrugge and the other border forts, because what happens there is as you go through border control, you then go into the huge queuing area in the harbour where there are clandestine entrants waiting to get into vehicles once you've passed border control. And so the question then has to be asked, at Calais and Dunkirk, and here we're concerned with Calais, do you conduct your final check at the gates of Calais Harbour as you would if you were at Coquelle, or do you conduct your final check in the terms of the Code of Practice, which says immediately before boarding the ship? Because you quite often have to wait several hours in that queuing system with a couple of hundred other vehicles before you board your ship. We've all been to Calais, we all know the process there. We park indeed in the same lanes as the trucks. And so what is a... And so what is a haulier to do reading that provision? He gets to Coquelle and he throws open his doors as suggested, just outside the gates to the shunting yard, if you like. He gets to Calais and he goes through border control, let's say successfully, without clandestine entrance being discovered. And then whilst he's parked up for 6 hours, because he's not required to make any more checks, he takes on a couple of clandestine entrants and they end up at Dover. But he's done everything he ought to have done by passing through, successfully accept his final check. And the problem is that if you require him to make the final check just outside the gates of Calais, other than the obvious logistical problems, is that he's still susceptible after he's been through.
Well, the closer you get to the ship, yes, the easier it is to target, for a clandestine to target, because they know you're there.
Just so.
So if you do your final check 20 kilometres before you get to Calais, you have a sporting chance of avoiding them, or may have.
I would say further, but I'm not going to get into the argument.
But
yes, the basic proposition...
That's the basic proposition you're making.
Is yes, but even then you're still susceptible, because when you stop at border control and pass through and go into the parking yard, there are, we've all seen them, there are clandestine entrants. They are very, very clever.
Can I raise another of my questions, please, which was on my list?
I fear I'm giving evidence which not to be doing.
But there's an accreditation scheme.
Yes.
And I spent some time looking at it yesterday, but it isn't clear to me at the moment whether how it works, because I understand that if you're accredited, that is a benefit if you happen to be stopped at Calais, you can, or wherever it's meant to be. But I don't know what the criteria are. Clearly, if you're accredited, it apparently means that the Secretary of State says, at least on paper, your system looks okay.
That's the essence. I mean, again, I draw back from giving evidence.
Well, that's fine, but what would be, I think, material for us, would, in the light of your submissions, would be if the criteria for satisfying the accreditation scheme, or being admitted to the accreditation scheme, were in any respect different, either by addition or omission, from the terms of the code.
They're not. They're essentially the same. The idea, as I understand it, this is my own view, is that the accreditation scheme is further encouragement for response call operators to make sure their systems are in place and to demonstrate to the border force that they have the systems in place. The idea being that once they get to the port, they're not waved through like any other truck simply because they're accredited. But if clandestine entrants are discovered and the scheme that was approved by the accreditation process was in place, then there will be no penalty. The discretion is exercised in their favour. That's the essence of it. But you're back again to if C is not complied with.
Yeah. Is there any monitoring in the accreditation scheme?
There is. But I rather suspect the Lord sees the confusion that is confronted by the trucking companies that have to deal with this.
Can I just
Lord
ask?
had a question.
Sorry,
Yes,
I did have a question. Going back to 1.2 of the Prevention Code, which is on page 11 of your skeleton argument, I understand your point that if you have to throw open an otherwise sealed vehicle immediately prior to boarding the ship or on arrival at Coquelle, that's the golden opportunity for that to happen, which is this whole scheme is designed to avoid. But tell me if I'm reading 1.2.5 wrongly. We get 1.2.2 tells us that you've got to check the seals, locks, or other security devices if they are present.
Yes.
Then we go on to check inside the vehicle. One possibility is you've got effective detection devices, and that, to me, completely ignorant, suggests that that's a way of avoiding the problem you've talked about. You've got your vehicle sealed or locked, you've got effective detection devices, whatever they be, heat-seeking, movement detectors, whatever, I don't know. In that situation, you can check inside the vehicle without throwing it open, and you won't have that problem. Then it goes on, where it's not possible to secure a vehicle by means of lock, seal, or other security device, a thorough manual check. So that bit that you've emboldened covers a situation where you don't have and can't have a lock, seal, or other security device.
Yes.
So the situation that you're hypothesising is a limited one. It's where you read 1.2.5 as requiring an inside check of the vehicle, which has got seals on it, and compels you to remove them in order to carry out the thorough manual check.
Yes, the effect, again, for want of giving evidence, the effective detection devices are operated by the French authorities and by border force. Dogs, vehicle X-ray systems, heartbeat monitors, which they apply to the side of hard-skinned vehicles, and carbon dioxide detectors. These are not things that can be carried by trucks. And so, I say these are not things that can be, these are not things that are carried by trucks because they're enormously, for one part, enormously expensive, but also I would suggest impractical. If you want to invest in a heartbeat monitor and a CO2 detector, etc., then all well and good. But I'm afraid the reality is that companies don't because they're so expensive. And I complain about paragraph 1.2.5 because the vast majority of vehicles fall within that group of vehicles that don't have. I've never seen a vehicle with that equipment. I have to confess. But the problem is the ambiguity. If you look at 1.2.5 in the scheme as a whole, the ambiguity of 1.2.5 and the rest of it suggests that you should check internally, but the problem is to check internally involves the removal of all that security equipment.
Yeah, I mean, there are two possible answers, aren't there? One is that check inside the vehicle does not apply, if you look at it in context, to a vehicle that's all sealed up and locked up.
Yes, that's the problem.
And the other is to say, well, if it does apply in that situation, you can't have an effective system if you comply with the code.
You have it. Yes, that's the problem. And that's why the code is imprecise and ambiguous, and why it's well, we've agreed. It's not to be taken as prescriptive. But the difficulty we have is that it's what's published and it is contained in Annex A as well, and it's what people seek to follow, and they fall foul of the ambiguity.
But from our point of view, I know I rather boringly keep going back to the three appeals that we have before us, but what do you say, or in which appeal do you say 1.2.5 and its alleged ambiguity has impacted upon the outcome of the case.
I think it's His Honour Judge Godsmark. If you'll give me a moment to confirm.
Well, I know you'll be taking us to the appeal, so just for the moment, I can just make a note
Yes,
that it's in relation to the Godsmark appeal that you say that 1.2.5 is relevant.
Yes, it is the appeal of...
That's the 13 people with the hole cut in the roof.
It's Mr O'Carn's.
Yeah.
Yes,
Yeah.
Driver O'Carn.
All right, thank you. Yes, do go on. So,
and so I don't know whether, because again I'm very alive to the fact that you've read all the documentation, I don't know whether I need to go on any more, if you like, about my complaints about the code and the way in which it's formulated.
Anything else you want to do on that?
Oh yes, well, I think this still qualifies as a general question. What are telematics?
It's a day for giving evidence. Most vehicles these days have a global satellite positioning system fitted to them by the driver, but they're far more sophisticated than that because they allow direct communications between the driver and his, they call them planners, the chap back at the office watching his route. What it means is that in real time, the guy at the office with the computer screen can watch the progress of the vehicle. Routes are planned, and so he can see if the route plan is deviated from. They've saved lives. I know a case where a truck was stopped for 72 hours and shouldn't have been, and they sent the police to it and found the driver in considerable degree of distress. And I say that because it illustrates how effective they can be in assisting in the implementation of effective systems of prevention. And you quite often find operators sending messages over the system.
We do in one of these, in I think the Co case we do.
Yes.
Yeah, sending the text to say, have you filled in? Have you?
Exactly so.
Yeah, and then if they didn't get the reply back,
No.
telephoning them.
Yes.
Yeah. No, I think certainly for my purpose that you've been very clear and highlighted the issues that you need to and wish to in relation to the general propositions.
Do we want to ask for a definition of effective?
Feel free.
I can't give you one, but it's not the one I submit that.
No, it's not the one that HHJ Fine came up with.
No, thank you. Do I need to argue that point?
I wouldn't have thought.
No, thank you. Can I move on then, please, to the level of penalty code? And an learned friend in his skeleton argument, and in due course on his feet, will say that this is not a point for which permission to appeal was granted. I dissent from that proposition on the basis that when we talk about the giving of reasons, it's probably clumsy language on my part. What I mean is the way in which penalties are, the way in which the level of the penalty is arrived at. Because what we have is a code of practice which sets out a number of factors to be taken into consideration when imposing penalties. But to date, nobody has said how the starting point, how the maximum is met, and how people should be calculated to have penalties imposed in them in respect of, I don't know, half complete or half effective systems of holding. Really, the argument is this: if somebody has a penalty imposed against them and they don't really understand A, the reasons for the specific setting of the level of that penalty, and B, how the penalty is calculated in terms of, if you like, in the criminal sense, sentencing guidelines, then how is an appellant to argue against the particular level of a penalty?
Well, there's two issues there, aren't there? One is, have adequate reasons been given
Yes.
for the imposition of the penalty? But you seem to be saying that that the code is defective by failing to have some sort of elaborate sentencing structure like we have for murder.
I use that as an analogy. I don't say that. And it's not about whether or not a penalty ought to be imposed, because
No, we've done that.
we've moved on to that, and we're now about what should the level of penalty be. And if your starting point is maximum, and for each element of...
Why would your starting point be maximum?
Well, because it is.
No,
It's not in evidence here, but that is, forgive me, what the Border Force has said in the past.
All right.
The way it's approached is they take the maximum and they deduct an amount for each, and this is anecdotal, for each element of an effective system which is present. But the difficulty is they don't say how much they deduct, and they don't say at what point you should start, and perhaps most importantly, they don't say which elements they have made allowance for in relation to the level of penalty code of practice, which again is not prescriptive. And so all I ask for in that respect is not an elaborate sentencing guidelines council document that says this is that and whatever. All in my submission is required is for the Secretary of State and the court to say it's been decided that the penalty is to be imposed. I calculate the penalty on this basis. You have failed to do this, this and this. You have done this, this and this. My starting point was X, and taking into account those factors, I arrive at Y. That's, I submit, a simple request, but it's one that is not being complied with in any of the jurisdictions within which these penalties arise, and it's frankly unfair. How do I argue against the penalty which goes, the penalty is £1,200 and no more? That's the complaint. Unless you would wish me to, I don't propose to spend any more time on it than that, because
No,
that is the complaint.
That's very clear, thank you.
Thank you. We have argued discretion to death, so I'm not going to go back to that, which is what comes up next in my skeleton argument.
I think we're on to the appeals themselves, aren't we?
Well, forgive me, yes, I have been asked to make one point.
Of course.
And it's circled here, and effectively I've made it, but the word arbitrary is the word I'm invited to use, and I do so.
In relation to
the election of the level of penalty. There is an arbitrary feeling about which the figure is arrived at.
Are you talking, just so I can be clear, are you talking about the way in which the Border Force operate, or the way in which the courts have operated in these cases? Both.
Because more often than not, the court, when they reimpose penalties at the same level. And that's the feeling that one is left with, is a sort of arbitrariness as to where we get to where we are.
Well, we looked at that paragraph in the fine appeal 24.
Yes.
Just so that I can understand what you're saying. What more do you say is required?
Well, my Lord, when we move to the individual appeals, I think I deal with
Will
that.
you deal with it then?
Would you mind awfully if I got to it in due course, so to speak? Thank you. And so I turn to the first appeal. They're in numerical order, so my skeleton argument, I'll call it link and cosicha, if I may, for short. Your Ladyship was right to suggest that the facts are largely agreed. I've highlighted here a tilt cord and seal had been applied to the vehicle. The tilt cord had not been applied properly and the vehicle was therefore not secure. It's not in dispute that the second appellant did not comply, that's cosicha, the prevention code of practice, because he did not properly apply the cord, and so access must have been gained. We never know how persons gain access, but that's a reasonable inference. The driver did not produce any written instructions carried on the vehicle. A checklist detailing the checks he'd completed was carried on the vehicle. And just slightly backtracking, that checklist is one of the items with which I complained about, and you'll know about that, and its role. And the argument is very simply, does the absence of a checklist make an otherwise effective system ineffective? And I would argue not. And interestingly, Border Force quite often, always demand a checklist upon stopping the driver, but there is no requirement in the Code of Practice for them to do so. They are required to produce on demand in the immediately preceding paragraph.
Well, that doesn't even quite say that.
The written instruction, sorry?
It doesn't even quite say that. On my reading, you're in the general principles, 1.3.2. I mean, the clear implication of 1.3.2 is that it should be available to be produced immediately, but it doesn't use prescriptive language that one might expect to see, though you are right to say that 1.3.3 doesn't go as far as 1.3.2.
Yes, but even 1.3.2 is regarded by the courts and the Secretary of State as being a mandatory requirement. And operators fail for want of, as they have done here.
Mandatory in the sense that it is mandatory to produce it immediately if requested to do so, or mandatory that it's mandatory to carry it.
Can I turn up the code? Because
yeah, it's at page 33, I think, wherever, of the authorities bundle. Or at least that's where I have it.
No, that's fine.
That's correct.
the general principles section. 1.3.1, vehicles should be checked regularly en route to the United Kingdom to ensure that they have not been entered, particularly after stops left unattended. A document detailing, 1.3.2, a document detailing the system operated to prevent unauthorised entry must be carried with the vehicle so that it may be produced immediately to an immigration officer on demand in the event of possible liability to a penalty. That's what is colloquially referred to as the written instructions.
That's the system.
That's the system, yes. And one can see the common sense behind the requirement. It's to remind the driver, if he's bothered to look, as to what he's supposed to do.
But it's also to evidence to the border force what your system is.
Well, yes and no. It's the beginning of the evidential stage, because then, as your Lordship was pointing out earlier, we then need to get into evidencing. I don't like that word, but anyway, to providing evidence as to the training, etc., that we come at later stages. But yes. And then 1.3.3, a report detailing the checks that were carried out must be carried with the vehicle. That's the end of the encoding.
But the effect, if you comply with that, is it's just as available for production to the border force.
It is. It is.
So you could say it is implicit, so that it may be produced immediately to an immigration officer on demand.
You could so. You could. I don't disagree.
But just isn't there.
I don't disagree with that proposition. Maloney Friend, I think, makes the point in his skeleton argument that, well, naturally, if you're supposed to have it, then you should be able to produce it. The problem is we're back to what is the overseas haulier to understand by these fine distinctions, because it's very easy for us to analyse it in the way that we've analysed it and say, well, the obvious inference is that if it's there, it has to be produced.
And I'm not sure why that's a fine distinction.
Because although the code is provided in other languages, it's one has to first of all assume that the driver understands the request that's being made of him. We see in one case
Well, wouldn't that go to training? That your drivers have to understand?
We can't teach them English in order to...
No, but they...
I don't mean to be flippant, sorry.
No, but they know that, but presumably the training requires an understanding of what
It does. It
what
does.
has to be done, which will include that the written instructions have to be in the cab, as must the checklist.
And what is produced is something in Romanian, which a border force officer won't recognise.
Well, that's his lookout.
Sorry?
That's his lookout.
Yeah, yes,
and one bears in mind also that this comes under the heading of general principles,
yes,
rather than rules.
yes. But they're in a code of practice which we understand to be what it is, but which those non-English speakers may not have quite such an understanding. And forgive me, lorry drivers cannot sensibly be expected to also be linguists.
How many lorries does Link run?
Oh, would you give me a moment? About 800.
So there's no problem with, in terms of resources, for Link to understand, subject to your submission that it's inherently ambiguous.
Yes. But that is my submission, because it doesn't really, I suggest, matter how many vehicles are operated. The person in the front line is the non-English speaking driver with his non-English documentation.
But he's been trained, hasn't he?
Sorry?
He will have been trained in his native language, or her native language,
Yes.
Not by reference to this document, or even the Polish equivalent of it, but by reference to some simplified instructions that the haulier has created on the basis of this document. So here's the document you've got to have in your cab. And here's the other document you've got to have in your cab. That's a reproduction in simpler language than
yes, I accept that. The issue for me is that's all well and good at the point of training, but if the document is provided after the event, as it so often is, and as it was in this case, it can't be for the Secretary of State or Border Force to say it wasn't carried, only that it wasn't produced upon demand. But there's always that ambiguity about the demand process, is the simple point. So I go on to the, forgive me, the Link and Kosica
Yes.
appeal. In determining whether or not an effective system was in place in this case, the learned judge said this at her paragraph 16. The system must be an effective system, and although it's been submitted on behalf of the appellants that this was an effective system, it clearly did not work.
Well, sorry to interrupt you, but I think a few minutes ago we all
did,
accepted
and
that.
as I'm reading ahead, I'm spotting
Yeah, that we. I don't think you need to make any
So
further submissions about that. I think we're all three of us are with you on that.
Yes, the learned judge is 17. The appellant's system of checking on the driver was not an effective system. It relied on the driver completing a single tick box form with no effective check that each step had been correctly completed by the driver. Even after it was known that the clandestine entrants had been found on the transporter, the relevant tick box form was analysed and approved by the first appellant as having been correctly completed by the driver, and the problem with the incorrectly installed tilt court was not identified. It would have been effective and appropriate, for example, to require drivers to take photographs or a video on their mobile phone showing that the tilt court had been properly applied and that the other required steps to secure the vehicle had been correctly followed. I submit the learned judge erred in arriving at that decision. I'm not going to talk about effective, which is my next paragraph.
Do we know whether that was a conclusion based on a submission made by the Secretary of State, or whether it was the judge's?
No, the paragraph itself suggests
The
it has
suggestion
been
that you
submitted
need,
on behalf of the respondent that effective is to be given its ordinary meaning, which means it works and
No, no, no. I think
No, I'm looking at the last sentence of paragraph
Oh,
17.
Yeah.
The suggestion that an effective and appropriate system would have been, for example, to take photographs or a video, so forth.
Well, give me a moment. I wasn't there, but my manager.
No.
No, that was something the judge.
That's the judges, because that seems to go rather further than the code.
Yes.
It'd be surprising if the Secretary of State said, well, here's the code, but here's some other things that could be done.
Yes. Well, my lord's was correct. It was correct.
Does the Secretary of State seek to uphold that as a necessary part of an effective system? Taking photographs and stuff?
No, my lord.
Thank you.
My lord, all I would indicate, of course, is that
Do you want to
given that my learned friend and I agree that the code isn't prescriptive, it follows from that both the court can be more demanding as well as less demanding, because the court only has to have regard to the code. My submission is that substantial weight should be given to the code, but the court does have the power, like Her Honour Judge Fine here did, to decide that additional measures are, in the court's view, necessary.
Without evidence?
without being your case?
If the court was persuaded on the basis of evidence, I don't know what the case was here. All I would say in respect of Her Honour Fine's decision is that this is in effect obiter, because her key finding was, of course, that there was a failure on the day. I'm not sure where this paragraph fits in with her reasoning.
All right, thank you. You can address this further.
I make a number of complaints about that paragraph 17, but one of my complaints is the proposition that the checklist, the report to be carried, was a tick box exercise. And one of my complaints is based on this. The Border Force themselves are very helpfully, or the Home Secretary has very helpfully published a pro forma checklist, what we call a security checklist, which appears in the bundle.
Could you just give us the reference of that?
Yeah, most certainly. It is page 208 of the SCAT supplementary bundle.
Sorry, 200 and...
208 of the, I use the shorthand, the SCAT supplementary bundle. That means it will be in the first part, the first folder rather than the second.
Thank you.
One page?
208.
208.
Yeah, but it's a one-page document.
It is, you have it.
Thank you.
Thank you.
To put short, complain that the completion of a document provided courtesy of the Secretary of State for the purpose is nothing more than a tick box exercise, is in my submission a complaint about the pro forma itself and not a complaint about the driver's acts or omissions.
Well, let's start at the beginning. Do you accept it's no more than a tick box exercise?
No.
Because it features large in the code.
It does. Well,
And doesn't it serve the same purpose as a risk assessment or a checklist in any other risk-based situation?
no, yes and yes. No, it doesn't feature largely in the code. What the code requires is I've got the exact wording now, a report to be carried. And this is the recommended report to be carried. But thereafter, I agree entirely with my Lord's proposition. But in terms of a tick box exercise, what this does, in fact, is it prompts the driver to do that which he should do and to make a record of the fact that he has done it. If it's a tick box exercise, it's a tick box exercise to that extent. He puts them up to say he has done what is required of him on the various occasions
I'm not sure there's anything between you and the Secretary of State here, because clearly a driver could abuse the system and just
Oh,
ticket
yes.
whatever.
Oh, yes.
But the purpose is to focus his mind and to ensure that the system is operated correctly.
Forgive me, if I've not
But
made it,
that, you're in agreement about that?
yes, if I've not made it clear, I don't complain about pro forma.
It's the terminology tick box you say seems to suggest some. No?
It goes beyond that. It's for where the learned judge says this is a tick box exercise, it's to denigrate the proposition that the driver has done that which he ought to do.
Oh.
But what he ought to do is tick the boxes and put the seal numbers in and make the appropriate marks. That's the point.
Do not denigrate.
Sorry?
Do not denigrate. Your submission is you should not denigrate.
Yes. This is a good document. I don't complain about it. I complain about the way it's, as my Lord says, been denigrated. And if that is one of the, that denigration is one of the foundations for the learned judge's finding that there was no effective system in prevention in the first place, then I submit respectfully that she has fallen into error. That's the complaint about that part.
Thank you.
I've also, I think, and I suspect I don't need to make it again, at the point, at paragraph 22, the learned judge says this, that of her judgment, forgive me. My paragraph 67, 66 I've reproduced it. The submission has been made on behalf of the first appellant that the driver was on a frolic of his own. I'm not going to go back there, we've dealt with that. But the driver was carrying out his duties. He was not on a frolic of his own, he was doing his job, but he did not check the tilt cord and the first appellant's monitoring did not work. The defence under section 34 is not made out. I do complain about the reference to monitoring, because the point I've already, I hope, made is that monitoring, as far as the prevention code is concerned, is not a, I use the term loosely, requirement of the prevention code. The issue of monitoring goes to the level of penalty. And so here I submit what the learned judge has done is she's taken the issue of monitoring out of the level of penalty part of the test and inserted it into the effective system of prevention test. And that, I submit respectfully, was her error.
If she had said the defence under fails because section 34C
Yes.
had not been complied with,
Yes.
you wouldn't have taken any objection.
I
But
wouldn't.
what you're saying is monitoring also, A, shouldn't be there anyway, and B, impacts on the effectiveness of the system as well as the operation by the driver.
Yes, and the difficulty is if that reasoning is the reasoning the judge applied, then it is incorrect reasoning, and one does not know to what extent it affected her decision to find that there was no system in place.
Understood.
But the issue is slightly larger than that, and it's a point I've made a number of times, and it's about where monitoring really lies within this statutory scheme. And when I say I look to the court for guidance on those aspects, if the court were, for instance, to say, we find that monitoring is part of the level of penalty code, and therefore has no role to play in whether or not there was an effective system in place per the prevention code, that would assist those from all sides who have to deal with this statutory scheme as it stands now. Of course, we've already discussed that's all going to change in due course.
Can I just ask your assistance on monitoring a bit more, because you've gone to 22, but isn't the starting point on monitoring paragraph 18? The last sentence of 18, it's not an effective monitoring system. So we understand from the judgment that at some stage, someone within the first appellant logged and analysed, but we don't know how, analysed the checklist.
Yes.
And they decided it was fine. But the judge says this is not an effective monitoring system because it failed to pick up that there was a problem even when the first appellant would or should have known that clandestine entrants had been found on board. Yes. Now, what we know is that the tilt cord wasn't properly attached. And what I don't at the moment understand is how an office-based analysis of the checklist is meant to pick up the fact that the tilt cord wasn't properly attached.
It can't.
The judge clearly thinks that, I mean, I can imagine that if the level of analysis is that when the trailer or the truck gets to the depot, the analyzer goes round and checks that everything is in order, but even that would presuppose that despite what happened at Calais in this particular case, the truck got back to the depot or wherever the delivery point was, still with the tilt cord.
In the same condition, yes.
So
it can't.
Was there any evidence before the judge about what analysis is carried out of the checklist?
Would you forgive me for that?
Mm-hmm.
Minimal, I'm told.
But they just look to see if it's all been filled out.
Yeah, I would imagine that to be the position.
Well, it would be fair to say that that doesn't add much to a row of beans.
No, that's right.
I think in paragraph 18 of the judgment there's reference to page 48 of the bundle, which seems to be some evidence of what took place by way of a paper check.
Yes.
And it looks like it was a check that all the boxes have been ticked.
Well, yes, all the boxes have been ticked and correctly filled out, because one has to recall that it's not just a ticking of a box, it's also the insertion of seal numbers.
It's monitoring of the effective completion of the form.
Yes, but one struggles to see what more a system could be of monitoring. As Manor points out, ex post facto back at the base. But the second argument I would advance against the proposition is this in any event.
I see, looking at note 3 on the checklist, which I admit I hadn't looked at till you took us to it. That does give us some idea of the approach of that difficult 1.2.5. If travelling throh Calais or Dunkirk, the final check should be carried out before entering the UK control. If using another port, final check should take place immediately before boarding.
Yes, but that's to misquote the code of practice. And this document has no prescriptive effect, and it is nothing more than a pro forma, adopted widely, yes, but nothing more than a pro forma set up by the Secretary of State to assist hauliers coming into the United Kingdom. But going back to the monitoring point, the two arguments I would raise about that, in addition to what Lord has already identified, is to penalise on this occasion, as this judge did for want of monitoring, is to penalise for an ex post facto act or omission. Because what the company does after, weeks and days and weeks after the incident has occurred, can have no effect on determining the issue whether or not there was an effective system in place and being used on the day. That's a criticism of the company's failure to react. But the failure to react can't assist the judge in determining what was in position on the day. And I accept it may be a legitimate criticism. And if it is a legitimate criticism, surely it goes to level of penalty and not whether or not there was a system of prevention in place, because that's what the codes tell us it goes to. And if the codes tell us it goes to that, then our Polish hauliers can be forgiven for thinking that that's what it goes to.
Thank you.
Yes, I reproduced the relevant part of the Code of Level of Penalty at my paragraph 68. I shan't read it, we're familiar with it, and I'm just picking up where I left off. But then we turn, having made my complaint about the judge's findings on the first point, that's whether or not there's an effective system in place, we turn to in operation on the day, which effectively is the driver's bit of it. Because what I submit is that what Link had done is they had provided an effective system of prevention. The question is, had it been followed properly? And that is, as has been pointed out, an entirely different question. And in this case, it has to be said, it hadn't. The driver may have done his checks and ticked his checklist, but he hadn't installed the tilt cord, as they're called, effectively. And so I don't complain about the imposition of a penalty on the driver himself. It's really whether or not his acts and omissions can be properly laid at the feet of the of Link. And we've had that conversation, and it takes us on to the exercise of discretion. Because it is at this point where I would argue that if the judge had found, if my arguments had been effective, that there was an effective system available, but it wasn't implemented on the day by the driver because of that failure to properly deal with the cord, then that is the point at which the judge must ask himself or herself, do I now exercise my discretion not to impose a penalty on the haulier on Link because they've done what they ought to do, but they've been let down by their driver? And my submission is that in these circumstances, one would expect, one would hope that the judge would do so. What the learned, forgive me.
I'm sorry to keep interrupting you, but I'm trying to make your life a bit easier on this occasion. We've been told that the Secretary of State doesn't support the last sentence of paragraph 17. I think it would be helpful at some stage to know whether the Secretary of State's position is that B was satisfied in this case, and if so, if not, in what respects it was not satisfied, and where that is identified in the judgment. And the other thing, which, speaking entirely for myself, I would find helpful, would be if your learned junior could possibly just give us page references for the evidence that was before the judge about system.
Yes, of course.
And that doesn't need to be done by any particular time, but if before tomorrow, that would be helpful.
You'll have it before tomorrow. Okay. I can't speak for my own friend and his instructions.
No, we will hear from him in due course.
Would you forgive me a moment? Can I, in answer to your question of the Secretary of State, take you, please, and I hope I'm forgiven, to paragraph 45 of my learned friend's skeleton argument, which appears, I think, at page 34 in the scat bundle, marked.
Sorry, we're talking about the skeleton argument for these proceedings? I mean, for this appeal?
For this appeal, it's in the, for convenience, it was placed in the scat core bundle, behind my skeleton argument, and it starts at page 34A.
Okay, thank you.
I hesitate to rise, but if it assists the court, I have spared loose copies, which I could hand out.
Yes, thank you. Yes, please.
Yes, whilst the appellants might have had an effective system in place. That's
My Lord has
Yes.
it, yes. I don't know whether that answers the question entirely, but that's...
well, they're hedging, I think,
Yes.
saying it doesn't really matter because C wasn't satisfied.
Yep.
Yes, well, that's for my learned friend to deal with, I think.
It's the same, I think.
Thank you.
Yes.
Would you like to have it?
No, I have it, yes. In fact, it is the same as the one we'd already got.
Yeah,
But thank you.
paragraph 45.
Yep, we have it, thank you.
My Lord has read the paragraph out. The appellants do not try and challenge the finding of primary facts. Hence, whilst the appellants might have had an effective system in place, it is not disputed that it was not operated correctly on the day and the driver had acted negligently. I wonder if that goes some way to answering
Yes,
my Lord's
thank you.
question of that aspect of his question. And so
I would like the hedging to stop, because if
Yes.
if it is accepted that B is satisfied, then your learned junior doesn't need, unless she particularly wants to give us the references for system in this case.
to some extent, my Lord, that deals with the way in which I move on with this appeal, I think. And I wonder perhaps whether we might ought to take a few minutes, and I would really appreciate a convenience break in any event. I don't know how the...
Yes, certainly. Well, in that case, we'll rise for 5 minutes. And
Over to you, Jonathan, I think, on this point.
Yeah, I'll try to take instructions.
Yeah, sure. Should we nip outside? You've been scribbling away, Adam? Oh, yeah. Can I suggest we deal with your scribblings at that much time? Because this is for just a short different piece. You've done the video.
Yes, yeah,
Watch
trainees just come to
Let's see how
watch.
not to do it. think we're still waiting. I've just come to scribble a note.
The live stream's a few minutes behind reality, so my solicitor hasn't seen that yet, so she's taking the instructions.
Okay. Regardless of pride. Jonathan, I think you'll look at it this afternoon.
Are you ready to start?
I think,
Okay.
yeah, I've not got that.
Are you ready?
Yes.
You got your instructions?
No.
Dr. Rice?
Yes, Mr. Clark.
It's not for me to speak for the learner friend, but it seems that this is being watched by those who instruct learner friends, and the live stream is slightly behind, so they've not seen the point come up yet. So I think we're still waiting for the instructions.
Well, don't worry, we'll deal with it when you rise to
I'm
make
grateful, my
decisions.
lady. I will have a look at my phone occasionally because I will be sent instructions.
Certainly. Well, please don't worry about it. In fact, we'd just said before we came in that we would leave you to deal with it at your own pace when you come to stand up.
I'm grateful, my lady.
Yes, Mr. Clark. Now, where have we got? Are we just about finished with the
We were about to
HHJ
attack-
fines?
We were about to attack discretion.
All right.
But can I, forgive me for this, but I've been asked to raise 2 points, and I do so willingly. Very short ones. But in my submissions, I may have lost sight of what you may regard to be something that's quite important. We have to remember that the legislation appoints, if you like, responsible persons, and they identify whom those responsible persons might be. And then the legislation provides for the imposition of a penalty, possibly, against each of the responsible persons. In effect, what that means is the company of itself is a responsible person and may or may not avail themselves of the statutory defence. Separately, the driver is a responsible person, and separately, he may or may not avail himself of the statutory defence. And so, to one extent, and to a limited extent at that, one must consider the positions of each separately. And I say this goes to my earlier argument as to, and I'm sorry to resurrect it, as to the laying at the feet of the company the failings of the driver. Because if one looks at it on that analysis, the question then becomes, does the haulier have in place an effective system of prevention, B, and was it properly operated on the day? And so the emphasis then becomes properly operated on the day. How does a haulier properly operate the system on the day? In my submission, he provides his driver with all the tools and training that is required for the driver to do his bit and properly operate his side of the system on the day. And if the operator has provided his driver demonstrably with all of the tools and training that he needs, then query, as far as the haulier is concerned, does he meet C as well? Because for his purposes, he has properly operated the system on the day. And the reason I put it like that is because, and it's our fault entirely, we ought to have laid the accreditation scheme before you. And in a moment, I'm going to ask you permission to do so later on today or tomorrow. Because it seems that the accreditation scheme, on our recollection, makes that distinction and suggests that if an accredited haulier, a haulier who has met the requirements of having an effective system in place, is let down only by the acts or omissions of a driver, then the haulier shall not suffer a penalty. And if that be right, then my somewhat forlorn argument of earlier in the day, I would perhaps hope to at least resurrect to that extent. Which is why...
These are not JR proceedings?
No, they're not. No, that's one of my biggest points I've been answering before you. They're not JR proceedings. But I'm not questioning the... I'm not seeking a public law analysis of the accreditation scheme. What I'm suggesting is that the argument that goes, don't lay the mischief of the driver at the feet of the haulier, is reinforced if the Secretary of State's policy is not to do so.
Doesn't this really go to stage 2 discretion? First, the first stage of discretion before penalty, that if it's down only to operator error, in accordance with the accreditation scheme, the presumption is there'll be no penalty.
Well, it's not
it's not a presumption, I'm bet.
But that's the point. If it were a presumption, I would agree entirely with Milady. But it's not a presumption, it's a policy, if you like. And I hear what Lord says about judicial review. But if it is the policy of the Secretary of State to exercise her discretion, it's not an exercise if it's a presumption.
No, I shouldn't have used the word presumption. Forget I said that. I just meant it goes to the discretion as to whether to impose a penalty.
I would agree with
But you're
that.
saying it goes to the defence also?
Well, if the Secretary of State takes the view that the haulier has had an effective system in operation on the day,
Understood.
but for the driver and therefore is not going to impose a penalty, then that goes to whether or not the system's effective or not. And if the accreditation scheme says that if the haulier's done everything they ought to do, the haulier won't suffer a penalty, that's not an exercise of discretion. That is a statement of fact. The position is you won't have a penalty. And if that's right, I submit it adds some force to my argument that goes...
Well, was the accreditation scheme before HHJ Fine? I mean, was this submission made to her in support of whether a penalty should be imposed? I mean, I know that she found that there wasn't an effective system in any event.
Forgive me, it arose in one of the other appeals
All right.
that we're going to deal with. It's simply I was asked to make these points and I was happy to do so.
Fine, thank you.
So that's that. But I suppose the biggest draw from that is we are dealing with separate responsible persons. And so exercise of discretion. Well, her paragraph 23, the learned judge said this. The next issue is whether the Secretary of State exercised their discretion appropriately not to impose a penalty. The first appellant is a commercial operation which has a previous record of breaches and penalties. The regulations are well founded and are supported by clear codes of practice. The intention of the regulations and law are clear, and the intention is to prevent exactly what happened in this case, the transportation of clandestine entrants in such vehicles. I find it proper to exercise the court's discretion to impose a penalty in these circumstances. I also note that there has been no suggestion on the part of the first appellant of any intention to change any of their practices, even though they clearly demonstrably failed on this occasion. The proper exercise of the discretion results in the position of a penalty, and the level of penalty code of practice starts at, and then makes a reference to the bundle before the learned judge. I complain about that for a number of reasons. The first is trite and obvious, and it's about whether or not it's a review of the Secretary of State's exercise of discretion, and say no more about it. The reference to the intention of the regulations being, quote, to prevent exactly what happened in this case, the transportation of clandestine entrants in such vehicles, is, in my submission, not the intention of the regulations, as indicated by this court in two previous appeals, the Bolly appeal and the International Transport Rough appeal. The intention is to encourage, with a, if you like, a stick and carrot approach, but to encourage responsible hauliers to do what they can in order to prevent this menace from taking place. On the matter of no suggestion of any intention to change any of their practices, I would submit that that goes to the issue of future conduct. And the question being, do I exercise my discretion in this case, or on the facts as I've found them? That is a different exercise of discretion than one which goes, can I look forward and see if this company are going to do any better or any worse in the future? And that, I would submit, is not something that can properly be taken into account when exercising the discretion on the instant case, the case which... Isn't
it just like lack of remorse or recalcitrance? That's really the point, isn't it? Confronted with their error, they make no attempt to suggest they're going to do anything about it. It's a classic culpability factor, isn't it?
I take the point, but perhaps I look at it in too focused a view. But I would submit that what the company does going forward is, with respect, a matter for them, because if they don't behave themselves and they get caught again, and they are subject to ever higher penalties, which is a factor which can be taken into account. But that factor about ever higher penalties if they keep offending in the loosest sense of the word is a process of looking back at previous conduct and saying, well, you've had now a series of penalties and therefore you should pay more. This one, the exercise here is an exercise in looking forward, and in my submission, I thought...
Well, look at it the other way. If they'd come with a stack of evidence about how they were going to tackle the problem of clandestines in the light of their previous difficulties, that would undoubtedly be a feature that could be properly taken into consideration going in the other direction.
I tend to be slightly firmer about it than that, and would suggest that actually no. It's all very well a company, and this is the difficulty, it's all very well an appellant coming to court and saying, look, I should have lower penalties because I'm going to do this and this and this in the future, and look, here's all my evidence. For them actually to go and do it, and to some extent they may just be saying it because it's expedient to do so. But the bigger point is none of that can have any relevance to the issue that the judge is trying, which is, on the facts of this case, do I exercise my discretion? Because again, it's looking forward, and things change looking forward. And if you're in that sort of variable position, then what you're doing is you're asking the judge to say, I trust you going forward, or I'm going to ignore that, I don't trust you going forward. And that's not about...
realistic prospect of rehabilitation. Classic sentencing factor.
Well, we're getting into crime now.
But we're talking about penalties for conduct which will take into account what happened and the state of mind, the degree of culpability that's to be attributed to the person being penalised.
I would argue not, because these are not penal sanctions, and that was one of the important findings in the case of Warby. They are designed to encourage hauliers to do what they ought to do. And so the question for the judge exercising discretion is, are they encouraged? On the facts of this case, looking at whether or not I impose penalties in this case.
Right, so we've got your submission about the discretion in wrong exercise of discretion in 23.
Right, well, in that case, I'm not going to reiterate my complaint about the judge's finding that £1.84 is sufficient. I've said what I would hope to say in my skeleton argument, and I'm not convinced I could take that any further at this stage.
Thank you.
Can I say this? I would move on to the next appeal.
Yes.
I have one item to block, and I'm in your ladyship's hands.
Oh no, please carry on.
Thank you.
Can I just, before we leave this one, just one point?
Please.
One of the factors in the penalty assessment here was the fact that the first appellant was a commercial operation with a previous record of breaches and penalties. And I think that includes, doesn't it, the next case,
Yes.
because that came first.
Yes.
Yeah.
Yes. I've taken them in Civil Appeal Office numerical order rather than.
Yes. Right, so that's where we're turning to now.
That's it, we're
On
going
a
back.
Judge Coe's one for the incident that took place on the 25th of September 2020. So that was the checklist that was not produced on demand but was produced at a later date.
And I would add to my lady's summary, there was no dispute about the fact the vehicle was properly sealed, properly secure, that checks were made by the driver, that a checklist detailing the checks he completed after stops had not been produced on demand, and as you say, it was produced later.
The judge, different from the SSHD, the SSHD was not satisfied that it was a contemporaneously completed chapter, but the judge was.
Yes, and that's my point earlier on, my Lord will recall about we're concerned with the judge's findings.
Yes.
And that is a good example of where the judge found differently from the Secretary of State.
Yeah.
In this case, which I think was Her Honour Judge Coe, Queen's Counsel,
Yep.
she found that, save for the failure of the driver to produce the checklist, there was otherwise, as I find, compliance with the requirements. That's at paragraph 8 of her decision. Having found that, she then went on to consider the first appellant's monitoring of the driver's compliance with the required checks and concluded that the first appellant's, quote, monitoring of driver's compliance by the system put in place by the appellant was in accordance with the requirements, and I so find. That is clear evidence, as I find, of a system of monitoring which seems to me to be satisfactory in terms of the requirements. And I add, notwithstanding that this is in fact not a requirement of the Prevention Code in any event. The learned judge, having made those findings, moves us on to the sole issue on the statutory defence aspect of the appeal, because that went to the driver's failure to produce his checklist when required to do so. And the learned judge said this at her paragraph 9. It does seem to me that the failure of the driver to provide a checklist at that time does amount to a failure to meet the requirements. It is that failure which the respondent now emphasises. The checklist should have been produced when asked for. That failure is, in my view, significantly mitigated by the fact that the evidence was provided, albeit at a later date. It is not clear to me what the reason was for the driver's failure to produce it at the time. Given that it was produced at a later date, the Border Force officer asked about the systems, the checklist was not provided. This is one of those cases where I would submit the haulier has done everything. The court has found that the haulier has done everything, and the driver has done pretty much that which is expected of him, save for the production of this document, this checklist. If that's right, then all of the arguments I've rehearsed in relation to the efficacy or the prescriptive nature of the code of practice apply here. And in any event, as has been rehearsed, notwithstanding that one might reasonably expect that a document that should be carried ought to be ready for production, the Code of Conduct does not require it, and it was provided in any event.
Have you got a very simple point on this? Maybe I'm being too simple. The failure of the driver to produce the checklist when asked does not affect the effectiveness of the system. Full
Something I
stop.
said earlier.
That's your case,
Yes,
isn't
thank you. Thank you.
it? Do we need to be any more complicated than that?
And I think you can also point to a passage in the Secretary of State's skeleton argument at paragraph 53, which again may be a little bit hedged around, but it analyses this judgment as a finding of a failure to operate the system, and therefore that section 34(3)(c) lim was not met. It doesn't say in terms that the judge was finding that B was met, but that seems to be implicit if you read the judgment and this paragraph of the Secretary of State skeleton.
Yes. But if B was met, and the complaint of an own friend is that C was not met for want of the production of the document.
Yes, I understand you have that separate point.
Exactly so. Then my Lord's point stands. That's extremely helpful, thank you. But then, don't we go on to the issue of the exercise of discretion, because if it stands that the want of the production of that one document does render the system inoperative on the day, then we move on to, again, the exercise of discretion. And I've made those arguments, and I say those arguments apply powerfully to this case. I don't know whether the court want me to conduct an analysis of what the learned judge said, as I've done in my skeleton argument, again, here and now.
For my part, I've got it. Do you want anything else? Do you want that?
I rather get the feeling, I'm wrong, please tell me, that for better or for worse, the court has the points I seek to make here.
Absolutely.
Thank you.
Do you want to just deal with the quantum? Because, of course, in the One Judge Co case, she did exercise her discretion, didn't she, to reduce the quantum?
Well,
I mean, I'm sorry, it was a rehearing to have a different level of quantum.
I hate to do it to the lady, but this is, I'm afraid, an argument we consistently have below about whether or not it's a public law. Judge Coe, I think, reduced the penalty to £1,000 in total for the company. Oh no, that was the second offence.
No, I don't think so. A penalty of some £500 in respect to it, so it was reduced from £1,000 per person to £500. So, oh, was it 1,200? I'm sorry, it was 1,200 and down to 500. So down from 13,200 to 5,200.
Yes.
And the driver down from rather breathtaking 4,400 to 154.
Yes, that was because one of the considerations for the
Was his means. Yeah.
And sadly, many, particularly Eastern European drivers, are not paid as well as they ought to be, one might say. But that's, I suppose, to their benefit.
But your submission, so far as penalty is concerned, is that the judge's penalty was too severe, that it should have been, well, you would say no penalty at all.
But if there
as
is,
but if there was to be a penalty, it should have been nil.
yes, precisely so.
Thank you.
And that, lady, is where I leave that appeal, if I may.
Right. Well, shall we, in that case, we deal with
I'm hoping you'd
the third appeal after the short adjournment.
Thank you.
So, shall we say 2 o'clock, please?
Thank you. Last couple